Hello, and welcome to this instructional video prepared by Together We Are Stronger Legal Services. Today we are going over the landlord's guide to avoiding legal issues when renting. We will get into how to avoid legal problems and avoid unnecessary landlord and tenant board hearings. In 2006, the Residential Tenancies Act was integrated into the law. This piece of legislation governs every landlord in Ontario and has a detailed list of rules that every landlord must follow. Why is it important for landlords to know the rules set out in the Residential Tenancies Act? Firstly, knowing the rules beforehand is a good way to reduce complications when drafting up rental agreements or dealing with problems that may arise during the rental process. Additionally, knowing the rules from the get-go is a good way to maintain a healthy landlord-tenant relationship. It is also important to know what your rights are and to be able to know when they have been violated. Finally, if you know what rules there are, you can protect yourself against false claims. If you are convicted of an offense under the Residential Tenancies Act, the penalty is a fine up to $50,000 for an individual and $250,000 for a corporation. In this first section, we will discuss tenant rights. We will be discussing illegal entry, lock changes, vital services, interference with enjoyment, harassment, the eviction window, and tenancy agreement issues. First, we will discuss entering the rental unit and how to avoid illegal entry. In most cases, 24 hours of written notice must be given to the tenant. The written notice must set out the reason for entry, the date the landlord will enter, and the time of entry between 8 a.m. and 8 p.m. You can enter a unit without notice in any case of emergency or with the consent of the tenant. If you have given the proper notice and the tenant does not allow you to enter regardless, this is an offense on their part. Tenants also have the right to be protected against arbitrary lock changes. This means that you cannot change the locks during a tenant's residency without giving them a new set of keys. You also cannot charge them for changing the locks. Some valid reasons for changing the locks without giving a new key are the tenant has been evicted and is gone, or the tenant has been evicted and they refuse to leave. You will need to get permission from the sheriff in the latter case. If you are not sure if the tenant is still living there, you can apply to the LTB for an order terminating the tenancy pursuant to Section 79 of the Act, which pertains to abandonment. Invalid reasons for changing the locks are being upset with the tenant and doing it as a form of revenge, or doing it to evict the tenant prematurely. Tenants also have the right not to have their vital services interfered with. This means that you cannot deliberately turn off their heat, fuel, electricity, gas, or hot water for arbitrary reasons. If you are experiencing non-payment, bring up the issue with the Landlord and Tenant Board before proceeding with any actions. If you are contractually obligated to provide care services or food for your tenant, the same rules apply, as these are considered vital resources under these circumstances. The discontinuance of non-vital services such as cable may enable the tenant to apply for a rent decrease as the value of the property is impacted. You may shut off services temporarily to do repairs, but you must notify the tenant first. If you are concerned about energy usage in the unit, you may install a suite meter. Suite meters are devices that measure electricity consumption. You can use these to monitor the amount of electricity your tenant is using, but remember that they still must be informed about the portion of energy that they are consuming before they are charged. You must also inform the tenant if you intend to stop taking responsibility for supplying electricity. This will impact your rental agreement. As a landlord, you are not responsible for the overall well-being of your tenant. However, if you are found to be doing things that deliberately interfere with the enjoyment of your rental property, then you can be punished. For instance, if you come to the property every morning and blast loud sirens to disturb the peace because you happen not to like your tenant, this is an offense under the Residential Tenancies Act. Interpersonal quibbles are best solved amicably with the help of a third party. If you do not get along with your tenant, discuss this with them and see if you can make other arrangements or end the rental agreement. Your tenant also has protections against harassment, obstruction, coercion, threats, and interference. Harassment is defined as repeated and deliberate negative contact that serves no other purpose beyond creating emotional distress. Offenses under the Act include threatening your tenant, interfering with their life and affairs, harassing your tenant to move out of the rental unit, trying to stop a tenant from taking part in a tenants association, preventing them from taking part in a hearing, preventing them from filing an application under the Residential Tenancies Act, or preventing them from exercising their rights. Your tenant has the right to a 72-hour availability of the property after eviction. This period is used to gather possessions and sort affairs before the tenant moves. It's an offense to immediately lock out a tenant after eviction. Be careful when drafting up your rental agreement between you and your tenant. Your tenant has a right to have their own written copy of the agreement for their reference. The agreement must also be sufficiently detailed and include any verbal agreements made between you and the tenant. For instance, if you agree to provide health care for the tenant, that must be put in writing. Any agreed upon changes must also be reflected in the updated version of the rental agreement. In this section, we will discuss some of the most common situations that cause legal problems for landlords. We will be discussing maintenance, evictions, rent, and fees. Maintenance is one of the most involved aspects of renting. Maintenance requires constant attention and diligence and can often be costly. As a landlord, it's your job to ensure that the residence is in a good state of repair, meaning that there is nothing that is dangerous or unusable. It must also be fit for habitation and compliant with health, safety, and housing standards. This means that there cannot be hazardous materials such as mold, broken electrical components, or messy areas filled with equipment. It is your responsibility to ensure that every unit is in working order. You have the right to enter a residential unit with 24 hours notice for inspection and repairs. Eviction is a complicated process, and there are many reasons why you may have to evict a tenant. Sometimes, it is a voluntary agreement to end the lease between you and your tenant, and other times it can be rather messy. In the interest of keeping things simple for now, I will outline the offenses related to eviction. For more information on your specific situation, please visit the Landlord and Tenant Board section of the Ontario.ca website. Under the Residential Tenancies Act of 2006, it's an offense to 1. Not follow the process set out in the Act. Evictions must follow the process set out in Part 5 of the Residential Tenancies Act. This section is called Security of Tenure and Termination of Tenancies, and it outlines rules regarding notices, agreements, renewals, disposal of property, and much more. It's very important that you read this section as a landlord before you evict a tenant. 2. To seize a tenant's belongings without consent or permission. For instance, you cannot move all of the tenant's belongings out of the rental unit before the finalization of an eviction without the right permissions to do so. 3. To make a tenant move out of a rental unit by giving a notice of termination to the tenant for a reason known to be untrue. This means that you cannot make up a false reason for evicting a tenant. 4. As we discussed earlier, changing the locks to the rental unit or building without giving the tenant a new key. 5. Giving a notice to end the tenancy of a rental unit so that the landlord can convert it into a condominium without the correct permissions. 6. Evicting a tenant so that major repairs or renovations can be made to the rental unit without compensating the tenant or offering them another acceptable place to live. 7. Failure to offer a tenant the right to first refusal after major repairs or renovations or when the building is changed into a condominium. And 8. Stopping the tenant from getting their belongings within the 72-hour eviction window. Rent can be a particularly tough subject to understand the nuances of. There are many rules involved with setting and increasing the rent price. I highly encourage you to check out the Landlord-Tenant Board's website for more information when you decide to change the rent on one of your properties. For now, let's go over what constitutes an offense when it comes to rent money. Offenses include charging more than is allowed under the Act, charging additional rent after the tenancy has ended and the tenant has moved out, forcing a tenant to pay a rent increase before approval, forcing a tenant to buy anything from the landlord in order to stay there, for example furniture, refusal to provide a receipt on request, charging fees that are not specified in the agreement, failure to return a deposit if the tenant does not actually end up moving in, using a tenant's rent deposit for something other than last month's rent, and not paying the tenant annual interest on their rent deposit. Due to market changes, the amount that your tenant will pay in rent will likely change slightly each year. Generally speaking, you want to follow the rental increase guidelines set out by the minister each year. However, there are some exceptions when you can increase the rent beyond this amount. These reasons include an extraordinary increase in municipal taxes for the residential complex, capital expenses for extraordinary renovations/repairs, and an increase in operating costs due to an increase in the amount you must pay for security services. If your rental increase falls under any of these circumstances, you must make an application for a rent increase above the guideline, or AGI for short. You can do this through the Landlord and Tenant Board. In this next section, we will briefly visit a few examples of unique living arrangements to go over some of the less common rules you may want to be aware of. We will discuss care homes, mobile home parks and lease communities, and nonprofit co-ops. Along with the offenses we already discussed, care homes have their own unique set of offenses. Care homes provide housing for people who need care services. This can include healthcare, rehabilitation, or assistance with daily living. In a care home, it's an offense to withhold or interfere with the reasonable supply of care service or food, interfere with additional services provided to a tenant by an external care provider, for example, a healthcare provider, or prevent the tenant from getting additional services from a person of their choice, for example, a family member. It's also an offense to increase the cost of care services or meals without giving 90 days notice of the increase. And finally, to give notice of a rent increase or notice of an increase for a charge without giving the tenant an information package first. Next, we will go over mobile home parks and land lease communities. What constitutes a mobile home park or a land lease community? Mobile home parks are land on which one or more mobile homes are located and used as a permanent residence. A land lease home is a permanent dwelling that is owned by the tenant but is built on land that's rented from the landlord. Along with all the other rules stipulated in the Residential Tenancies Act, it's also an offense to stop a tenant from buying goods or services from any person, interfere with selling or leasing a house/mobile home on the land, and finally, to force a tenant to sign an agency agreement for selling or leasing a house on the land. What this essentially means is that despite the fact that you own the land that the house is on, they still have the right to rent out their mobile home or house as well. Nonprofit housing co-ops have their own set of rules under the Cooperative Corporations Act. A co-op is a residence that is managed by the residents or members themselves, or they can have member-elected boards that fulfill a management role. These buildings can also be occupied by non-members who fall under most of the common rules in the Residential Tenancies Act, with some exceptions for obscure rent rules. It's best to investigate further on your specific matter when dealing with non-residents in nonprofit housing. Offenses for nonprofit housing co-ops include stopping a member from belonging to, taking part in, or forming a members' association. It's also an offense for a member to interfere with or prevent a nonprofit housing co-op from exercising their rights, such as filing an application under the Act or taking part in hearings. And finally, it's an offense to take possession of a member unit without following the rules specified under the Residential Tenancies Act or the Cooperative Corporations Act. In the final section of this video, we will be discussing some final notes of importance. Some miscellaneous offenses to keep in mind are disobeying an LTB order requiring you to do specific repairs or stop doing certain things, to stop political candidates or their agents from canvassing on the property, to stop an investigator from entering a building to carry out a search warrant, for an agent representing a landlord or tenant at the LTB to charge a contingency fee that is higher than 10%, and finally, giving false information to a rental housing enforcement unit for the landlord and tenant board. Here are some final tips for renting out your property. Firstly, it is always a good idea to keep a record of all correspondence between you and your tenant. This assures that hearsay is kept to a minimum and that all affairs are organized in an easily retrievable place. If you ever have trouble with your tenant, or they would just like some clarification on the agreement, it's an asset to have everything in writing. Secondly, screen all your tenants before drafting a rental agreement. This is normally done as a quick interview. Getting a feel for a tenant is important to screen out bad matches and establish a landlord-tenant relationship. Thirdly, keep records of any receipts regarding the rental unit. This will make tax season much simpler and will assure that you remain organized financially. Fourthly, keep a good line of clear and open communication between you and your tenant. It's best to know about any problems before they escalate, and having communication between you and your tenant assures that you are the first to know if something needs your attention. Additionally, this is a good way to establish a friendly relationship with your tenant. Finally, inspect the property for damage at regular intervals. It's important to inspect for potential damage to keep your possessions out of harm's way. It acts as a deterrent and holds a tenant accountable for damage. Additionally, you can write the inspection into your rental agreement so the tenant is aware of this arrangement. All the information compiled in this video can be found on the Ontario.ca website and is public information for all Canadians. Keep in mind that this information is only a set of guidelines. All matters are decided in court. However, knowing these guidelines is a reliable way to stay out of trouble. Please visit the links listed here for more information. If you would like to talk to someone about your specific rental needs, please contact Abby Rosen at Together We Are Stronger Legal Services. With 50 years of real estate experience, Mr. Rosen can help you clear up any questions you may still have. Additionally, he specializes in real estate-based legal matters. Thank you for listening. We hope that you've learned a lot and we wish you luck with your rental properties.